I have a great pleasure in welcoming you all for today's session, where we are going to discuss the very important topic of fast-track merger. Today, Dipti will not be able to join us because due to her preoccupations. And nevertheless, we have two of the great panelists. We have Mr. Anant Jha with us, who has got a varied experience over 2 decades of the experience. And of course, we have our own Sudhakar. This particular topic is very, very important because this has been introduced in the Companies Act under Section 233, very recent past. Because this is actually gives you the flexibility for the smaller companies, startup companies to merge with not much of the procedural involvement, not going through the NCLT, which take the longer process. And this has been actually aimed to do with the ease of doing the business, with a cost-effective manner, and also it is having a lot of flexibility. Of course, anything what we talk about it will have its own complexity also, especially when it involves the foreign companies, foreign entities, etc. The necessary sectoral regulation, such as RBI, foreign exchange regulation, all those things will also apply. Anyway, our panelists are going to discuss with this. I think it is my duty to introduce Mr. Anant Jha. Anant Jha is actually coming with the rich experience of over 2 decades of the experience in the diverse field, like secretarial compliance, legal counseling, statutory audits, and process of re-engineering. And especially, he is also having a founder member of the AK Jha and Associates, and he has got a lot of prominent clients across the India and public sector undertaking and various MSMEs, etc. And not only that, he is also an IICA registered independent director and also a IPR attorney. And definitely his professional credentials include International Valuation Certification Program, that is IVCP of the Indian Institute of Corporate Affairs. And he is also a law graduate from the Agra University of the Delhi. And he has been also he is also an independent director in some of the organizations like International Business Values Association, and also a consultant to TR Chanda and Company. And his rich experience definitely includes the companies where he has actually worked, like Usha India Limited as a Deputy General Manager, SAS Motors under management in Karji Ceramics, etc., and other thing and all. With his various experience, he is rendering advisory to the various clients of his. And also he is appearing in the NCLT, NCALT, and IPR related issues and representing various regulators, including ROC, RD, SEBI, and other places. He comes a very, very rich experience. And during our session, he would be sharing his practical experiences, and he will actually give the insight of this particular topic. We will have the benefit of having his own experience. And of course, Sudhakar, as you are all aware, I don't need to introduce him, but he comes from the very bigger conglomerate where they handled multiple issues. And definitely, he also will be sharing his experience coming on the fast track merger, because they also done a lot of merger. Some of them, they have not gone for the fast track. He will have the valid reason why he did not choose to go to the fast track merger, etc. We will hear from them. With this, I will hand over the mic to Mr. Anant Jha to address the audience about the topic and his thoughts on this. Over to Mr. Jha, please.
Good morning. Thanks for your nice introduction. It is really a pleasure to be with you. And Sudhakar sir is there. He is a big authority. He always inspired us when it was matter of secretarial standard. He was leading the team. And I always got some guidance from his team. The topic which is chose today is basically restructuring of company. I am taking you to history, why it was needed as a fast track merger. there was a J.J. Irani committee whose report was placed in 2005. And that committee recognized the importance of merger and acquisition as a driver of growth and business strategy. And that committee recommended the streamlining the process of adopting international merger acquisition model. Because in India at that time, the merger was basically looked by High Court or court which was defined under Section 10 of the Companies Act 1956. So that committee recommended to have some sort of provision in our act such that we can facilitate fast track merger in India, aiming to streamline the certain merger process, tackling challenges, procedure, and delays. So fast track merger was basically introduced to promote ease of doing business by permitting fast track merger for certain classes of companies, including holding companies and their wholly owned subsidiary companies, small companies, startup companies. So considering all these, Ministry of Corporate Affairs introduced Section 233 of the present Act, Rule 25 of Companies, Compromise Arrangement and Amalgamations Rule 2016, which enables fast track merger without requiring intervention or approval from NCLT. Since the constitution of NCLT is a tribunal, which is quasi-judicial body, which having its procedure, and constitution of NCLT was basically with purpose to save the time of High Court to have a specialized matter in corporate law matters. So CLB, Company Law Board, was being replaced by this NCLT. Full-fledged court was there. So basically it was dedicated for the company law matters. But considering that every sort of case is being referred to NCLT, this fast track merger is being given as a power in Companies Act itself to the administrative powers, to the government itself and governing mechanism. As the central government representative is regional directors in each jurisdictional region, they are authorized to look the matter of this fast track merger. So basically it is dedicated for easy procedure. And its legal insight is being totally framed in section itself, section 233, and its power is given to RD, and RD is basically the authority who passes the order. The mechanism of this approvals is basically executory approvals, and further that order is being registered with MCA, and accordingly all company which is transferred merge with the existing company and this procedure. I think this I will take up the all technical things. Oh, thanks. Let this
Over to Sudhakar, please.
Yeah. Good morning, everyone. Further to what Anant has said, is as far as the fast track mergers are concerned, this is one of the objectives of the government to ease of doing the business. There are several initiatives were there under the Companies Act 2013. And one of such initiatives is, as Anant has rightly mentioned, it was a J.J. Irani Committee's recommendation way back in 2005, but ultimately it could see the daylight in 2016. But even in this also, though it is a good initiative, no doubt about it, but the amount of liberty what was to be given to the corporates, it was not given, because the fast track merger is applicable only to the merger of the wholly owned subsidiary company with the holding company, or small companies mergers among themselves, or startups among themselves, or startup with small companies like this. But if two wholly owned subsidiaries have to merge among themselves, that is not coming under fast track merger. Similarly, if a subsidiary company has to get merged with the holding company, that is not happening. Because in big conglomerates, that we do have, for operational reasons, for business exigencies, we do keep floating new companies. And after the purpose is over, those companies need to be wrapped up. And one of the ways of doing that is the mergers only. So earlier, there was a long route of whether going to the courts or whether to go to the tribunals. And ultimately, the fast track merger has been given because the small companies which are within the groups, you don't need to go through the quasi judicial process, and you can go through the executive process. But say, for example, in Reliance, we have n number of subsidiary companies, and we want to wrap up those subsidiaries. We have to go necessarily through NCLT route only. That's why in the finance budget of 2025, the Honorable Finance Minister has made a proposal even to extend this fast track mergers even to the subsidiaries also. I think already there is a consultation paper kind of thing is there, floated by MCA, and they have invited certain comments or any suggestions, observations, etc. from the stakeholders. And Disha is going to explain to us some of that. But certainly, overall, this is a cost-effective merger, and not only the efficiency cost-wise, as well as in the timelines also. Certainly, fast-track merger has proved the one of the efficient mechanisms which MCA has initiated. But this needs to be extended further because it is only half part has been taken care, and the remaining the half is still there. The beauty of this thing is it has already been extended to cross-border mergers also. Because if we have any foreign holding company, that can be merged. That is a reverse merger, we call it as that foreign holding company can be merged into the wholly owned subsidiary under this fast track merger route. In this fast track merger route, unless until the once you move the application, unless until the ROC and OL have any objections, which they raise within 30 days. Otherwise, it is by default, this is more or less approved. So it is a very efficient system. And so I give a pause here and request Disha to take it forward. And while she is making her presentation, we will discuss it further. Thank you.
Participants can put their questions and queries on the chat box as usual, which will be taking out from time to time. Yeah.
Yes. Thank you, sir. Okay. So I hope everyone is able to see the presentation.
Yeah, very much.
Yes. Yes, sir. So today's discussion topic is an insight into fast track merger. So for very first, what is fast track merger? So as Bala sir, as sir has, everyone has gave the introduction, fast track merger is a simplified process available to specific categories of companies under section 233 of the Companies Act 2013. So it is a quicker and less cumbersome process that does not require approval from the NCLT, that is National Company Law Tribunal. So instead of NCLT, it requires confirmation from RD, making it more efficient for eligible companies. So the fast track merger was introduced with the section 233 in our new Companies Act 2013. So the concept of fast track merger was introduced with the new Companies Act without intervention of approval from NCLT. And with section 233, the new rule 25 of Companies Compromise Arrangement and Amalgamation Rules 2016 was introduced. So basically, fast track merger was introduced to promote ease of doing business. And also, it aims at tackling the procedural delays, which are otherwise faced in the regular merger process. There are a few benefits of fast track merger, considering the ease of doing business. So where very first is that there is no mandatory approval required from NCLT in case of fast track merger. Similarly, no need of issuing public notice. There are less administrative burden, less cost, and it is time saving. There is less procedural complexity. Similarly, the procedure of fast-track merger typically takes around 90 to 120 days, which is significantly faster than the regular merger. It provides smoother group restructuring or consolidation among smaller or related entities. Also is beneficial in case of mutation of assets post-merger. So there are few legal aspects which we are going to cover in this PPT, considering the Companies Act, SEBI LODR, Stamp Duty, and Income Tax Act. Before starting fast-track merger, we have to fulfill few prerequisites of fast-track merger. So in prerequisites, the main part is that it shall be between two or more small companies, two or more startup companies, one or more startup company with one or more small company can be done, or a holding company and its wholly owned subsidiary company. And the important part is they should be able to give the declaration of solvency. So the companies planning for fast track merger shall declare their solvency to ROC and they should not be insolvent. This is the important part which everyone should consider. So to clarify further, we'll go through the definition part of the companies. So first is small company as per section 2 subsection 85 of Companies Act. So small company is whose paid up share capital which shall not exceed 50 lakh rupees or such higher amount as may be prescribed, that is which shall not exceed 10 crore rupees. In case of turnover, turnover of which as per P&L for immediately preceding financial year does not exceed 2 crore rupees or such higher amount as may be prescribed, which shall not be more than 100 crore rupees. So there are a few exclusions in this small company section, small company definition. The exclusions are holding company or subsidiary company, they are excluded. Then company registered under section 8 or company governed by any special act and public companies. They are excluded from the definition of small company. So after small company, the startup company. The startup company which are recognized by Department of Promotion of Industry and Internal Trade. So criteria for startup is which are incorporated as a private limited company, partnership firm or LLP, which are operational for less than 10 years from incorporation or registration. The turnover of which is not exceeding 100 crore rupees for any financial year since incorporation and are engaged in innovation, development, deployment or commercialization of new processes, products or are service driven. So we'll go through the definition of subsidiary company as per section 2 subsection 87. In relation to holding company, as everyone know, a company in relation to holding company means a company in which holding company controls the composition of board of directors or exercises or controls over half of the voting power along with its subsidiaries. Similarly, wholly owned subsidiary is which 100% equity shares are owned by another company, which will be said to be its holding company. So after the definition part, we'll go through the procedure of fast track merger.
Disha, 1 minute. Can
Yes,
we
sir.
go back to the previous slide, the definitions one? See, several times, that when this kind of mergers, whether it is fast track merger or any other merger, that is one of the methods of corporate restructuring. Whenever this has to take place, the pace is the essence, the speed is the essence, the time is the essence. So most of the times what we do is we are more concerned with the procedural part. Sometimes we may what's called as an ignore the basics. What is that basics? And okay, that I have said that when we started the masterclass series on Companies Act, the importance of the definitions. I'm very happy that Disha has brought this particular 2 slides wherein she has explained the definitions. Even when you are going for a fast track merger, first and foremost thing is you have to see that are you qualified to go for the fast track merger? So to get qualified, you have to see that your company is a holding company and your company is a wholly owned subsidiary. Wholly owned subsidiary is not defined anywhere. Now you have to see that wholly owned subsidiary, how you are arriving at, and are you sure that it is really falling under the wholly owned subsidiary? Number one. Number two, to understand that, you also need to understand what is a subsidiary company. Okay. So several times we got that kind of a confidence, or you may call it as overconfidence. We don't refer to the sections. We say it is subsidiary. Yeah, I know that very well. God forbid. Similarly, small companies, startup companies. It may so happen you might have issued capital and you have not taken it in the capital build-up, or your turnover might have crossed and you are not aware of that, and your company is no more a small company and you are not qualified for this, you will get stuck. Half the way, if you get stuck, you are losing the time. So whenever you have to start fast track mergers, whether you are eligible or not, that is very important, for which you need to understand the fundamentals, that is the definitions part. Yeah, go ahead, Disha.
Yes, sir. So we will go through the procedure of fast track merger now. After considering the eligibility, whether we are eligible for the fast track or not, we see the procedure now. So to start with the fast track, first every company has to check whether you are authorized for merger or not. After that, you have to conduct a board meeting. So for board meeting, you have to give 7 days advance notice. In board meeting, the board meeting is to be basically conducted by both the companies, transferor and transferee company. And the agenda for the board meeting will be to consider first approve the scheme of merger, then fix the date, day and time, place of shareholders meeting, then to approve the declaration of solvency, as we saw earlier that this is the important part, declaration of solvency, and noting and finalizing the list of creditors, the value of total liability towards creditors, and to appoint a valuer to issue the certificate. Again, the appointment of valuer to issue the certificate for fair value of shares, and this is not required in case of a wholly owned subsidiary. So the next step after board meeting is to file, where both transferor and transferee company have to file the notice in form CAA 9. CAA 9 is to be filed for notice of proposed scheme to ROC, official liquidator, for inviting their rejections or suggestions, if any, on the scheme. So here, in this case, ROC and OL are allotted a 30 days time period for their suggestions or any rejections. So they have a 30 days time period to revert on that. Similarly, the copy of the scheme or all the documents, basically CAA 9 has to be filed with Income Tax Department also, because Income Tax Department also plays a role here. Then CAA 9 is to be filed through Form GNL 1. CAA 9 goes as an attachment to Form GNL 1. Along with CAA 9, board resolution is to be filed, copy of scheme and affidavit confirming the scheme. CAA 9, as I said, has to be filed by both the companies, transferor and transferee company. Then comes the main part of declaration of solvency. So for declaration of solvency, form CAA 10, we will see all the forms in brief in the later slides after the procedure. So CAA 10 is to be filed by both the companies, transferor and transferee company. CAA 10 is filed through form GNL 2. So along with the declaration of solvency, this is to be filed with ROC. Here, statutory auditor has to issue certificates. The certificate under section 144, certificate confirming the relation of holding and subsidiary, confirming the list of creditors, secured and unsecured. Then, of course, CAA 10. So, here the important part to be noted is CAA 10 should not be based on the financials older than 1 year from the date of signing of the declaration of solvency. This is very important to be noted here. In GNL2 form, the attachments will be CAA 10, that is Declaration of Solvency, Auditor's Certificate, List of Creditors, certified copy of memorandum and articles of the company, and CAA 10, it should be on the stamp paper and notarized. So this is the third step. I'll go to the next slide.
No, 1 minute, Disha.
Yes, sir.
See that before even you go to the board meeting, another fundamental thing what you have to see is that whether this merger of the companies, whether you are going to get merged or you are getting merged, whether your memorandum articles have authorized you for that. That is very important. In fact, when we were discussing the bonus issue, that point of time, I have very elaborately explained that one company secretary who has, without verification of the articles, he has approached the board, he has put a business item on the agenda. One of the independent director has noticed that it is not covered in the articles. So he has questioned that how can we declare bonus even without getting authorized, because it is one of the requirements of the Companies Act is that unless otherwise it is, unless it is authorized by the articles. That means if the provision in the articles is not there, you have to amend that first and then you have to do it. The same is
Yes,
the
sir.
case here also. So several times what happens is that consciously or unconsciously, we forget or give importance to the fundamentals. And I always tell the budding company secretaries and the young company secretaries and the practicing company secretaries, whenever you take up a job in service, the company secretaries who are going to get into the service, the moment you go and join a new company, first and foremost thing is you have to be thorough with the chartered documents, that is memorandum and articles. What you can, what you, all things you have to have on your fingertips. As a company secretary, what you are empowered, what you are authorized for. In fact, last to last webinar, I have said that director has a right to ask the company to convene a board meeting. So obviously, he will ask the company secretary to convene the board. And that I have received such and such requisition from a director. Should I convene the board meeting? And the chairman says, no, don't do it. But if you see the articles, it is the responsibility of the company secretary that whenever a director is asking him to convene a meeting, he has to convene it. If it is so in the articles, then it is the responsibility of the company secretary to do it, even if the chairman is asking him not to do it. So unless until you are thorough with your articles, you will not be able to discharge your responsibilities as a key managerial person. Same is the case here also. Whenever you prepare a checklist or a timeline, this thing for the purpose of fast track merger, you have to start with the eligibility, as Disha has mentioned it. For the eligibility, you have to see that your company is qualified to be a subsidiary, wholly owned subsidiary, holding, small startup, etc., things. After that, are you got the authorization under the memorandum articles to go ahead with the fast track merger? Then comes the question of getting board approval, then the procedural part, all the other things are there. Yeah, Disha, go ahead.
Yes, sir.
You touched upon very rightly. I also keep telling all the people who take up the job, first you go through the article and memorandum of association. Because you might be joining the company which is incorporated way back in 1950 in the 1956 Act. So there are a lot of things which provision would not have been there. You know to actually pick up. For example, the buyback was introduced later than 2000, 2003 or something like that. That old article will not have that buyback provision at all. Wherever such things are required, where the regulatory thing, you know to get actually amended as early possible at the forthcoming general meeting, etc. That is another thing which they have to do it. You rightly touched upon very basic point. Second thing, one of the participants also sharing. Correlator also asked from the which class of the merger is permitted from the official liquidator is the query letter which is asked whenever this sort of the scheme is submitted. That's what one of the participants is actually sharing it. So you should be thorough with it, as you rightly said. Yeah.
And
Go ahead,
similarly,
Risha.
Bala, in fact, you have touched one more point also. You have said that certain companies' articles are the old articles under the Companies Act 1956. In fact, we know that very well. When the Companies Act 2013 has come, it is not mandatory for you to change your articles of association. It is not mandatory. There may be articles, but if they are overriding the Companies Act, obviously Companies Act provisions prevails. So you have to be very careful. Don't merely go as per your articles. You have to see that whether the articles are conflicting with the Companies Act provisions. If it is so, the provisions of Companies Act prevails. Now the question comes, why the articles are not amending? Because there may be several reasons for that. Several provisions relating to the promoters or their understanding among themselves, all those things might have been in the old articles. If you want to amend that, obviously the current shareholders' approval is required, which may or may not be given. So that's why some companies are hesitant to amend the articles. And as I told you, it is not mandatory for you to amend your articles. But the only thing is, if in the article certain things are there which, as per the Companies Act, you are not supposed to do, but as per your articles, you can do it. But obviously, Companies Act provisions prevails. So you, as a company secretary, or whether in service or in practice, go through the articles, understand that thoroughly, and have your own notes. Because every time you may not be able to be that alert or inquisitive to understand that. So once you are going through that, at the same point of time, have your notes also side by side, so that whenever you have to have a referral point, it will be easier for you to refer it. Yeah. Okay, Rishabh, go ahead.
Even some of the participants also sharing, if the article does not have the necessary provision, first it need to be amended, include before the fast track merger. You saw that's what he say. And again, he says if such a clause is not there in the MOA, need to insert the clause first and then call for the board meeting. The same view is coming out. Yeah.
Yes.
Now, to add more to Sudhakar sir and Professor Balakrishnan, generally what we practice at the time of checking eligibility for this fast track merger, we check the memorandum's provision whether they are authorized to merge or not. In that case, we take a specific provision that company can merge with these type of companies, and further we replace the article with new set of article is provided in Companies Act 2013. Because it is the opportunity where we take some special resolution to change the memorandum and article accordingly. Oh, thanks. Yeah, carry.
Yes, sir. So we also have to obtain here NOC from creditors. So we specifically have to obtain NOC from secured and unsecured creditors, for which we have to conduct the meetings. Also, we have to take shareholders' approval, for which we have to issue 21 days notice. 21 days notice for conveying the meeting of members and creditors. Here, you can issue a shorter notice if 21 days notice is not possible. Similarly, in creditors meeting, you have to take the approval of 90%. 90% of the value of secured and unsecured creditors. So this you have to keep in mind specifically, that you have to take a separate approval from secured and unsecured creditors. If the creditor is from any foreign country, then yes, their approval or their NOC should be notarized and apostilled. Similarly, the shareholders meeting. In shareholders meeting, you have to take the approval of 90% of value of shareholders through duly conveyed meeting. Then, after conducting of shareholders meeting or members meeting, here comes the filing of Form MGT 14. you have to file Form MGT 14 for the shareholders resolution. Then transferee company, the transferee company has to file the approval of scheme and report of result of the meeting in Form CAA 11. This CAA 11 is to be filed through Form GNL 1. So GNL 1 is to be filed to RD, ROC and official liquidator and also the income tax department. So the attachments with GNL 1 will be the creditor's consent, general meeting minutes, scrutinizer's report if it is a listed company, then CAA 11, CAA 9, CAA 10. In case of any observations, the reply given on them. Then the entire set of documents along with the memorandum of appearance is to be dispatched to the RD office or handover or hand delivery. You can give it by physically going there. Then comes the part of in case of any objections or rejections or suggestions. So upon receiving the scheme, the ROC or the official liquidator has to give their reply or intimate the same in case there are any objections or rejections, they have to intimate the same to central government within 30 days period, on which if the central government, then comes the CAA 12 form. So in case of no objection by the registrar or official liquidator, then order for approval of the scheme will be issued directly in Form CAA 12. In case of objections received by the ROC or OL, the central government may file Form CAA 13. If CG finds that the scheme is not in public interest, then the CG within 60 days will file an application to tribunal. So after considering the submission by central government, the tribunal will approve the scheme or reject the scheme. If there are no objections and the order is issued, as I mentioned earlier, if the scheme is approved and order is issued in CAA 12, then you have to file INC 28. So INC 28 is to be filed with ROC. If order is not issued and there is any objection, then CAA 13 will come into picture. So this was the procedure. We'll go to the tentative timeline of the procedure. So in fast track merger, as we said earlier, fast track merger is for ease of doing business. It saves time. So considering the timeline, if you see the days, so documents and board meeting, all the days are tentative, which differ a bit as per case to case. So documents and board meeting will take around 7 days. Then notice of proposed scheme to ROC and OL, 30 days period. General meeting of members, as we saw earlier, 21 days we have to issue the notice and conduct the meeting. Similar is the case with the meeting of creditors. And then approved scheme, the filing of the scheme, 7 days period. In case of objections, we have to intimate to the central government, which will take another 30 days. And then the central government, in case of objections, will file the application to tribunal, which will take another 30, it's 30 plus 30, 60 days. And after issuing of order, we have to file the INC 28, which will take another 30 days. So around 90 to 120 days period, tentative timeline is for fast track merger.
Disha,
Yes, sir.
to add more,
Yes.
to get NOC from creditor, sometimes it becomes very tricky. They give objection before the regional director that due to these apprehension, company should not be allowed to merge. And in that case, RD provides that let them get paid by the company to save their interest. In practical cases, what we have faced, we give some sort of declaration to them that they will be taken care even after merger.
Okay.
And it becomes satisfactory to the officer concerned. Thanks, please.
Yes. Okay, sir. So I've just given a brief here about the difference between the orders of merger issued by RD and issued by NCLT. So if we see the difference, basically the RD order is an administrative order and the NCLT order is a judicial and or quasi-judicial order. So as we saw earlier, in case of fast track merger, of course the order is quicker and less expensive. So I'll just go through the points. So nature of RD order, it is an administrative order which is issued after examining the objections and suggestions, which is binding and effective for approving the scheme under section 233 and is quicker and less expensive. In case of NCLT, the order is judicial and quasi-judicial order, which is issued after hearing all stakeholders and the objections. The order is legally binding and enforceable through judicial means and may include conditions or timelines and directions which are to be fulfilled. So, as I had mentioned during the procedure, these are the forms which are to be filed. A brief on the forms which are to be filed during the fast track process. So, I had mentioned all the forms during the procedure. So, CAA 9, which is to be filed through GNL 1, notice of proposed scheme to ROC official liquidator for inviting rejections or suggestions if any. Form CAA 10 is the declaration of solvency to be filed by both transferor and transferee company with ROC through GNL 2. MGT 14 for shareholders resolution. RD 1, transferee company has to file the approved scheme and report the result of meeting in form CAA 11 with RD. So CAA 11 will be filed through RD 1. Then comes the form CAA 12. So in case of no objection by ROC or official liquidator, order for approval will be received in form CAA 12. Form GNL 1, transferee company to file the approved scheme and report the result of meeting in form CAA 11 along with the earlier notice sent to with the ROC. The same is to be filed with official liquidator manually within 7 days from conclusion of the meeting. Form CAA 13, in case of objections raised by ROC or official liquidator, the central government may file CAA 13 before the tribunal. After consideration, the tribunal may reject or approve the scheme. And last is the INC 28, which is to be filed within 1 month of the order after receipt of the order to approve the scheme.
Sudhakar, although you can go through the fast track merger, I think some of your experiences, you decided not to go to the fast track merger, but still yet to go through the NCLT. The specific reasons, etc., if you could share, that will be nice.
Yeah, see that one of the reasons for that is though technically and legally, whatever the order given by the RD for the fast track mergers, the assets of the transferor company will become the assets and liabilities of the transferor company will become the assets and liabilities of the transferee company. But in case of immovable properties where you have to get that assets mutated in the name of the transferee company, you have to necessarily go to the stamp office for the stamp duty purposes, as well as you have to also go through the sub-registrar's office for getting the property mutated in the name of the transferee company. And for the reasons, okay, that they know that the court order, they know the tribunal order, but as far as the RD's order is concerned, they will dispute that. They say this is not the order. You have to go and get the NCLT order for the mutation of the properties. Otherwise, there will be a hindrance as far as the mutation is concerned. Now, you may say anything, but they don't budge. It is very, very difficult for you. So, if you are more what's called concerned with the timelines and get your job done, sometimes is though we are eligible to become to come under the fast track scheme, it is if the stakes are very high, especially in case of immovable properties, one has to take the call to go through the NCLT scheme. It may take a bit more time initially, but at a later stage, you can have a relaxed time. Otherwise, what may happen is that you are getting the mutation will become into a geopod. That is the reason actually we have taken some calls when I was there at Reliance. Despite the fact that we could have gone through the fast track budget, we have gone through the NCLT. Yeah.
Mr. Anant, your views on this?
Yes, sir. Sir, in this type of case where RD has given order for merger, we present before the revenue, especially in Delhi revenue, I have confronted with, they want justification. And why those orders, we present that it is at par with those orders. So can be treated as it is of NCLT. Since matter is discretionary before the officers, sometimes they accept it, sometimes they do not. But as Sudhakar sir has suggested, go through the NCLT, it becomes easier because it is defined as conveyance. And it comes in the schedule and they treat it accordingly. So it becomes a matter of shopping that which way should we go. Thanks.
So that means even though we say a fast track merger, it also comes with a complexity. So one has to take a decision. I think some or other is a high time. The regulator should look into it and give the proper thing so that, one side we are talking about ease of doing the business, other side these hurdles are coming up. Yeah. Yes, Disha.
Yes, sir. So stamp duty also plays an important role here. As earlier I said, there are different legal sites we have to go through in the fast track merger. So considering the stamp duty, so one of the major issues in M&A transactions is related to the implication of stamp duty. So it has been settled by various judicial pronouncements that the order passed by the courts sanctioning the scheme of arrangement is an instrument, and accordingly stamp duty is to be levied on this instrument. So under a scheme of arrangement, property is transferred from one person to another and accordingly falls within the ambit of the term conveyance as defined under the Act. It has been settled by various judicial pronouncements that the order passed by the courts sanctioning the scheme of arrangement is an instrument and accordingly stamp duty is levied on this instrument. So the rate of stamp duty on merger and amalgamations differs from state to state. So
In fact, one minute, Disha. In fact,
yes,
there
sir.
is Vikas has written in the chat box that in Delhi we are getting the mutation done on the basis of the RDA order. I'm not saying it is not, it cannot be done. What I'm trying to say is only that it will be, if you go through the NCLT road, the things will become easier. And that's what, that too also I said that when the stakes are very high, you don't have time with you. So there in that thing, and okay, because see what happened is the stamp duty and the mutation and all these things, these are all subject to the state laws. And okay, so it depends upon the state to state, depend upon the sub-registrar office and sub-registrar office also. Say for example, I will give a small example to you. Common seal is not mandatory under the Companies Act 2013. And suppose if you have given up the common seal, there are still several government departments. Whenever you have to enter into any agreement with them, they will insist on the common seal. You go and tell them that Companies Act doesn't mandate common seal. They say, no, no, we don't know anything, but you have to bring your common seal. So that's why, what happened is when I was there in Reliance, we ensured that the companies, all our companies have the common seals in place. And the procedure is there in the articles about how to affix the common seal. So it is a call to be taken by, but otherwise, for all purposes, the order given under the fast track mergers by the RD is not less than anything of the order given by NCLT. It is more or less equivalent. But only thing what I said is practical and pragmatic point of view. Sometimes you may have to take certain calls. That is what I have mentioned it here.
You're absolutely right, Sudhakar. Actually, it differs between the discretion of the people who are occupying the seat there in the different state. That is exactly the point, actually, what you have touched upon. When you came to the common seal, we also had a same problem. We were to execute an agreement with the, what you call power generation authority at Jamshedpur, where I told them there's a board resolution there, common seal not required, etc. They said nothing doing unless you bring the common seal, execute the order, we cannot give you the power connection. Very categorical. There is no other go. So sometime, as you rightly say, from the practical point of view, one has to take a judgment here. If you are able to get it, if you are confident, yes, this is good. If you are not, you are suspect, then it is going to having a hurdle. You have to choose the other route. It is one has to take a call, right? Definitely speaking. As Anant was also telling, he is able to convince some of the authorities. In some people may get convinced, some people may not get convinced. That is the problem. Yeah. Yes, Disha.
Yes, sir. So we have covered the rate of stamp duties here, which are applicable in different states all over India. Andhra Pradesh, Chhattisgarh, Madhya Pradesh, Gujarat, Kerala. So Maharashtra. In Maharashtra, the rate of stamp duty, which is 10% of the market value of shares issued or allotted and consideration paid for such amalgamation, provided the amount of duty shall not exceed 5% of the market value of immovable property located within Maharashtra of the transferor company, or 5% of the market value of shares issued or allotted and consideration paid, whichever is higher. So you have provided it that in case of reconstruction or demerger, the duty shall not exceed 5% of the market value of immovable property located within Maharashtra and transferred by demerging company to resulting company. This is a additional information regarding demerger. Then or 0.7% of the market value of shares issued or allotted to the resulting company and the amount of consideration paid, whichever is higher.
Sudhakar and Anant also would recall, in fact, those days when we were going for the IPO, etc., and other things and all these things, people who are situated in Maharashtra, they used to all the way travel to Delhi and conduct the board meeting and start issuing the share certificate from Delhi in order to save the stamp duty. Correct, na?
Yes, sir.
I also done the same thing.
So West Bengal, yes. These were the stamp duties which are applicable to different states here. Then comes the part of accounting standards. Here there are two, AS 18 and Indian Accounting Standard 103. So both of them, we have every company going for fast track merger has to follow the applicable accounting standards and the rules and regulations. So basically the small companies other than listed companies, in case of small companies and other than listed companies, AS 8, AS 14 will be applicable, and for listed companies or and large size companies, the Indian Accounting Standard 103 will be applicable. Going ahead, AS 14 prescribes two methods: pooling of interest method and purchase method. So here is a comparative chart of both the methods. So to tell in short, pooling of interest method is will be applicable where there is a common control over the companies who are going for the fast track merger, and purchase method will be applicable in case there is no common control over the companies who are going for the merger. Further, in case of pooling of interest method, considering the assets, so here in this case, all the assets of company, the companies which are getting merged, will be consolidated line by line with the other company, which is going to that is with the transferee company. And in case of purchase method, each asset and liability will be brought to their fair value and then they will be acquired. The difference between two methods. While going through any of the method, pooling of interest method or purchase method, whichever is applicable, you have to take a confirmation from the statutory auditors about the treatment, basically about the accounting treatment. So to go through the comparison of pooling of interest method and purchase method, pooling of interest method of accounting is one in which the assets, liabilities and reserves are combined and shown at their historical values as of the date of amalgamation. In case of purchase method, it is an accounting method wherein the assets and liabilities of transferor company are shown at their market value in the books of the transferee company as of the date of amalgamation. Usually, pooling of interest method is applicable in case of merger and here in case of acquisition. Then assets and liabilities. In pooling of interest method, they appear at the book value, and in purchase method at the fair market value. In pooling of interest method, all the assets and liabilities of companies are aggregated. The companies which are undergoing merger, the assets are aggregated and liabilities also. In purchase method, only those assets and liabilities are recorded in the books of transferee company which are taken over by it. In case of reserves, the identity of transferor company's reserves is kept intact in case of pooling of interest method. And the identity of transferor company's reserves, except statutory reserves, is not kept intact in case of purchase method. The difference in the amount of purchase consideration and share capital is adjusted with the reserves in pooling of interest method. And surplus of deficit of purchase consideration over the net asset acquired should be credited or debited as the capital reserves or goodwill in purchase method. So this was the short comparison between two methods. So going further comes the next important part, that is Income Tax Act. So we'll go through it. For in case of Income Tax Act, we first have to go through the definition, which is very important here. In Income Tax Act, in section 2, subsection 1b, here amalgamation means the merger of one or more companies with another company, or the merger of two or more companies to form one company in such a manner that there are few conditions which are to be fulfilled. All property and liabilities of amalgamating company or companies immediately before the amalgamation become the property and liabilities of the amalgamated company by virtue of amalgamation, and shareholders holding not less than 3/4 in value of the shares in the amalgamating company or companies, excluding shares already held by the amalgamated company or its subsidiary or nominee, become shareholders of the amalgamated company by virtue of the amalgamation. Considering the definition comes the important part of carry forward of losses in case of amalgamation, where section 72A comes into picture. Here in case of amalgamation, pursuant to the compliance of below mentioned conditions, this is very important, that pursuant to the compliance of below mentioned conditions, the accumulated losses and the unabsorbed depreciation of the amalgamating company shall be deemed to be the loss, or as the case may be, allowance for unabsorbed depreciation of the amalgamated company for the previous year in which the amalgamation was affected. Where there has been an amalgamation of a company owing an industrial undertaking or a ship or a hotel with another company, or a banking company referred to in clause C of section 5 of the Banking Regulation Act 1949 with a specified bank, or one or more public sector company or companies engaged in the business of operation of aircraft with one or more public sector company or companies engaged in similar business. An erstwhile public company, sector company with one or more company or companies, if the share purchase agreement entered into under strategic disinvestment restricted immediate amalgamation of the said public sector company, and the amalgamation is carried out within 5 years from the end of the previous year in which the restriction on amalgamation in the share purchase agreement ends. Further, the companies have to fulfill the following mentioned conditions also. The amalgamating company has been engaged in the business in which the accumulated loss occurred or depreciation remains unabsorbed for 3 or more years, has held continuously as on the date of the amalgamation at least 3/4 of the book value of fixed assets held by it 2 years prior to the date of amalgamation. The amalgamated company holds continuously for a period of 5 years from the date of amalgamation at least 3/4 of the book value of fixed assets of the amalgamating company acquired in a scheme, continues the business of amalgamating company for a minimum period of 5 years from the date of amalgamation, fulfills such other conditions as may be prescribed. In a case where any of the above mentioned conditions are not complied with, the set-off of loss or allowance of depreciation made in any previous year in the hands of amalgamated company shall be deemed to be the income of the amalgamated company, which will be chargeable to tax. This is important to be noted. Yes. Next comes the SEBI LODR part, where the requirement of no objection letter from stock exchange is exempted. The exemption is given for NOC, where the merger is between wholly owned subsidiary with holding company. After this, I have covered 1 or 2 case studies here. First one is the case of IDFC Limited versus Regional Director, NCLT, Chennai, 2022. The facts of the case were like as scheme of amalgamation under section 233 between IDFC Alternatives Limited, IDFC Trustee Company, IDFC Projects Limited with IDFC Limited. Here the applicant sought approval for a fast track merger under section 233 of the Companies Act. The transferee company, which was a listed company, failed to obtain the required 90% shareholders approval, securing only 52.09% approval. So despite of obtaining 99.9971% approval through e-voting, representing 52.08% of the capital, the scheme was rejected. So the issues here were whether the 52.09% approval meets the Act's requirement of 90% shareholders' consent, then the validity of e-voting, whether e-voting constitutes legitimate shareholders' approval, and objections under section 233(3), whether objections raised by the respondent under this section are valid. So the conclusion was, the tribunal found the scheme prima facie non-detrimental to shareholders' interest, and all statutory compliances were fulfilled, and the tribunal under section 233(6) of the Companies Act sanctioned the scheme of arrangement. Considering all the facts, the scheme of arrangement was sanctioned. Next is RD versus Hacienda Properties Private Limited. Then here the issues were whether the concerns for clarification fall within the ambit of public interest or interest of creditors as per section 233(5) of the Companies Act, and is the valuation a necessary requirement for mergers under section 233 of the Companies Act. So the public interest part, this concept is very important. In the given case, the regional director raised concerns about whether the proposed merger scheme was in alignment with the concept of public interest as mentioned in the Companies Act 2013. So public interest is a broad term that signifies actions or decisions that benefit society as a whole rather than specific individual or entities. So, in the context of corporate mergers, ensuring public interest means assessing whether the merger will have positive or negative impact on stakeholders beyond the companies involved. So, the court, applying the pari passu doctrine, asserted that applicants' concern for clarification fall within the realm of public interest. Regarding the valuation, seeking valuation of shares of transferor or transferee company is not a condition precedent for fast track mergers, and hence there is no mandate for the same for filing an application before the RD. Yes. So recently, MCA, via its notice dated 4th April 2025, has proposed for inclusion of more classes of companies for fast track merger under Section 233 of Companies Act, read with the Companies Compromise Arrangement and Amalgamation Rules 2016. So the proposed change is in Rule 25. We will go through the proposed change now. To be
Yeah,
specific,
this is only at the discussion stage today. It is not yet approved actually. These are all the proposals which are there. Once the scheme is approved, notified, then this will actually come into effect. As you know, when the things are actually being discussed and it's other thing and all, ultimately when we see the finality may be different than what it is actually proposed here, but Disha is actually sharing what is actually proposed by the MCA as on today instead of the fast track merger. Please take a note of it, because this is not in force, it is not given effect at all, it is not notified yet, but it will take some time. But when the finality comes, that we will know what is the real state of affair. Yeah.
yes, yes, as sir said, to be specific, this is proposed. So the proposed changes, I have purposely highlighted them in a different color. So existing, as we saw earlier also, that the fast track merger, which is between two or more startup companies or one or more startup company with one or more small company. So the proposed change, if you can see in here in the earlier side, proposed change in Rule 25 in Subrule 1A in Clause 2 for words small company. After that, they have proposed small company or third point, one or more unlisted company other than a Section 8 company with one or more unlisted company other than a Section 8 company. Here they have specifically excluded Section 8 company, where every company involved in the merger meets the following criteria as on a day not more than 30 days before the date of notice referred to in Clause A of subsection 1 of Section 233. The borrowings of the company from banks or financial institutions or any other body corporate is less than 50 crore rupees, and such a company has no default in repayment of such borrowings, or provided that a certificate from the auditor of the company that the company meets the conditions referred to in this clause shall be attached along with the application under subsection 2 of section 233. So if we can see, merger between two or more unlisted companies, all companies involved must be unlisted. Borrowing is less than 50 crore from bank or financial institution or others. No default in repayment of borrowing. Auditor's certificate required to confirm the above. This category allows financially stable companies to use the fast track route as long as their debt levels are in limits provided and they haven't defaulted. So financial stable companies can opt for fast track merger. Merger between a holding company which is listed or unlisted and its unlisted subsidiary. So the current position here is only merger of a wholly owned subsidiary into its holding company is allowed through fast track merger. And the proposed change is subsidiaries other than wholly owned subsidiaries can now be merged into the holding company under section 233. This enables group restructuring without NCLT even when subsidiary is not a WOS, that is wholly owned subsidiary, reducing the compliance burden and time. The merger between fellow subsidiaries, unlisted, under the same holding company. So the current position that this is not allowed under section 233, but the proposed change will be allowing two or more fellow unlisted subsidiaries having the same holding company to merge using fast track route. This encourages internal group consolidations without having to go through the lengthy NCLT process. Further, inclusion of cross-border merger, transferor, foreign holding company, which is already in Rule 25A, Subrule 5. So the current position here is Rule 25A, Subrule 5 allows foreign holding company that is outside India to merge into Indian wholly owned subsidiary. The proposed change here is to include this rule under the Rule 25 to make it self-contained. So this brings clarity and completeness to Rule 25 by consolidating provisions of cross-border fast-track mergers. Yes.
I think we will take questions now, whatever is there in the chat box, before we move on further. Whether prior permission from the RBI is actually mandatory before filing the merger petition with the NCLT in case of the two NPSC of same group having a majority directors and shareholders being same. Actually, we are discussing the fast track merger. We are not discussing the NCLT merger here. But however, any sectoral approval such as RBI, etc., which will be definitely required the prior permission actually before we going for it. Mr. Anand, your view please on this.
Very right, sir. In fact, I replied in chat box. The regulatory permission is required, and the regulator, one of the authority whose NOC for go ahead is required, and it is taken separately. In case of NBFC, since the regulator is RBI, they give permission. Similarly, in case of any insurance company, IRDA will come in picture.
In fast track merger, how much time is taken to complete the exercise? I think she has already put up the slide. She explained the time frame actually. RBI is a regulator and the concerned company will need to seek its approval. That's what here it is there. Okay. Prior approval from the RBI. Okay, it is required. Can we have the recording of this webinar? Yeah, this recording is actually disseminated via YouTube. You can actually access it. And many people are asking, can we share the PPT? PPT is not generally shared here. The disseminated webinar will be available and you can access to it. If the company has the negative net worth, somebody is asking a question. Mr. Anand, somebody is asking a question. If the company has a negative net worth.
So solvency certificate would be given if net worth is negative in some cases. Then in that case, especially NCLT route is there. So fast track merger would be opted.
Okay, somebody says small company is now 4 crores, etc. Yeah, that is right. The latest definition is 4 crores and subject to 10 crores, which is actually there. That is one thing. A company qualifies as a small company under the company. Yeah, this is what we talked about it.
See the picture. See the pictures.
While obtaining the no objection certificate from the creditors, is it necessary to have the document notarized and executed on the stamp paper? Kindly confirm the legal regulatory requirement, if any, with respect to the notarization and use of the stamp in such a cases.
Sir, as a matter of practice, RD asks for such thing. But
The
as
second
far
thing
as
is these are procedural matters and depends upon RD to RD office also.
Yes.
These are all procedural matters,
Yeah.
So they vary also. You cannot just say one RD has done like that, all the RDs will do like that. To a large extent, it may not be so.
So it is matter of satisfaction for the officer, RD.
Correct.
Somebody is saying, is it possible to share the draft schema of arrangement? See, the draft schema of arrangement will actually vary from company to company, circumstance to circumstance. There is no generic a standardized form or something like that. If you have the specific issue, please get in touch with the experts in the field. Mehta people are available, or Anand Jha is available. You can talk to them because there is no standard format for this sort of things. In the fast track merger, is it appropriate to take an approval of the creditors and shareholders after filing the solvency certificate with ROC? In the fast track merger, is it appropriate to take an approval of the creditors?
Sir, it is basically procedural part. So
Okay.
if RD is not satisfied with the given NOC, they can ask fresh. That we need, we are not satisfied, so that can be asked.
Okay. If the AOA doesn't have the clause that we have talked about it, AOA checking, etc., that's what people actually put here. It has to be amended. Can we hold the AGM and file annual filing form with ROC when merger is pending with the NCLT since the last 2 years? Because pending the merger with the NCLT is nothing to do with the compliances, because it is a going concern, because when the merger approval will take, the merging will take place. But till then, one has to continue to do the compliances, whatever the necessary filing, etc., and other thing and all. Just because merger is there, NCLT, you cannot stop any compliances. That has to be very clearly understood. Even if the companies which is going under the liquidation, the liquidator is bound to do the necessary compliances, etc. That is what it is called for. Correct, na, Sudhagar?
Yeah, absolutely.
Approval is required from the unsecured creditor as well as the fast track merger, given that they are not affected if the merger. How this is important?
The creditor has to justify in that case that due to this merger, certain thing will happen which will be against the interest of it. If
See,
it
let
is
me tell
not,
you.
then RD generally allows.
Yeah, that is right. Because see, what happens is creditors has always got a say what will happen to their liabilities, whatever is there, that is their concern actually. So long as that is not affected, they will not have any objection. I think even we also had a case. In one of the cases, we formed the compromise arrangement returning the excess money to the shareholders. In that case, what happens is creditors' approval was not actually called for, because company was a cash-rich company, we had it. But ultimately, at the time of the RD hearing, the major creditors objected, saying that, we are about the concern, the company is actually selling away the share, giving away the shares, etc. What will happen to that? Then we have to actually satisfy the creditor, we have to get the no objection from them, then only it was true. So definitely creditors' approval will be actually required here. We are their concern, we are their concern about safeguarding their liability.
And sir,
NCLT take, yeah. Yes, please.
as a synergy of this merger, we justify that due to this synergy, some more cash will be generated, debt equity ratio will be improved, and the creditor will have more security in that case. And the officer whosoever in hearing get this justification in writing. And accordingly, they convince the unsecured creditor that you will be more secured.
NCLT take the report of the ROC and compliance status. The irregularity, non-compliances can be rectified, filing the reason and yeah, that is what we said actually. I was in ROC Karnataka, I have some concern, but I would like to add that many judgments are there in which court said it is not power of the company to merge the amalgamate with the other, and it is a legal option and not the mandatory to have the MOA. Kindly offer your expert's view, please.
And in one case, Calcutta High Court held that it is inherent power. So, in a specific provision in a memorandum is not required. But my suggestion will be to have some express provision in memorandum of association.
Yeah, it is always better to have the authority in the memorandum or article of association to avoid any sort of the future litigations. It is always required, because it is one of the cases, as you rightly say, it just happened. But the thing is, it is always suggested it should be there actually. Can we obtain NOC from the creditors in the form of the written consent, or is it mandatory to obtain in the form of the affidavit and then notarize? We talked about it. This is a procedural issue. It all depends upon as per the requirement of the different regulators where you are situated. Have you practically seen any case where, because of the brand name of the company, in particularly being part of the major group, creditors, other concerned parties create issue for approval or concerns? Anand sir, somebody is actually asking, have you ever practically seen case because of the brand name of the company, particularly being a major group, creditor, other concerned parties create issue or approval of the concern?
Yes, sir, it is quite obvious, but it is factual thing. On the basis of circumstantial thing, officer take call on it. I have confronted several cases. Sometimes creditor use this tool to get their money in time.
Okay. Are we saying RD order is not enforceable in the court of the law? Can you please throw light on this? I think he's talking NCLT order and RD order, executive order and administrative order. Yeah.
Visa has given full-fledged slide on it.
INC 28 is INC 28 is required to be filed by all the companies failing under the scheme of the merger. Intimation to the income tax also required to be, this is the information he is actually sharing, which is Calcutta High Court held the power of merger of Indian and that we talked about it. In fast track merger, possible for the wholly owned subsidiary 100% or for a 99.999% subsidiary, just I share outside, is also possible under the fast track.
It will be allowed in this case, sir. The genuine apprehension should be genuine one.
At what stage is the questionnaire received from the audit or official?
Bala, I don't know what answer Anant has given. This 99.999 subsidiary.
Yeah.
Okay. It is not qualified to be under the fast track merger because 99 paisa can never become 1 rupee. So same is the case with 99.9999%, it cannot become a wholly owned subsidiary. So as on date, as per the prevailing law, it is not qualified to go under the fast track merger.
I will agree, but one more thing is there. Whenever you are talking the wholly owned subsidiary, I don't know. You correct me if my understanding. Because many times what happens is the companies, for the purpose of actually conducting the board meeting, they issue the nomination share to the people who are holding.
That is different. That is permitted. If that nomination share, if it is there that they have declaration that they have declared it under that section 89, okay, then it is fine. Then it is as good as the company is holding it.
Yeah.
But if it is not on behalf of the company, if he is not filing that forms under section 89, beneficial holding, then it is not a wholly owned subsidiary.
Okay. At what stage is the questionnaire received from the audit and official liquidator? Also, in case of the cross-border merger, where the resultant entity is the Indian entity, will the official liquidator even be involved? The questionnaire received RD and OL, there is a specified time limit is actually given that the 30 days time limit, within that only they will actually give. I think that is the answer to that. In case of the cross-border merger, where the resultant entity is the Indian entity, still the official liquidator even be involved. Yes, Anand sir.
Yes, sir. Can you repeat the question?
He says, at what stage is the questionnaire received from the RD and OL? The first question. Second question is, in case of the cross-border merger, where the resultant entity is the Indian entity, will the official liquidator even be involved?
Yes. Yes, official liquidator will be intimated.
In case of the cross-border fast-track merger, is it pre or RBI approval required or RBI approval not required, similar to the NCLT route?
Since it is capital account transaction, so HEMA applicability will be there. So obviously approval will be required in this case.
Yeah.
RBI
Delhi we are getting the mutation. That's what we address actually. Stamp duty differs from state to state. There's the information. In case a company is listed on Calcutta Stock Exchange only, whether NOC for approval of the scheme under SEBI LODR regulation has to be taken from Calcutta Stock Exchange. What is the course of action since CSC, Calcutta Stock Exchange, is not issuing such NOC? I don't know where is the Calcutta Stock Exchange. There are only two national trading stock exchanges there, NSE and BSE. All of the stock exchanges are actually outlived. There is nothing now today. The regional stock exchanges are where from this question I do not know. Narendra, if you are there, you can actually elaborate on this. I'm not able to get it because the regional concern of the stock exchanges is already gone. Now there are only two stock exchanges, one is the NSE and other is the BSE, nationwide trading stock exchanges. Okay. PPT, we talked about it. Only intimation to be given to the reader. Acha. Will process change if a holding company register office in Maharashtra and 100% subsidiary register office in Gujarat? Will the process change? One company is situated in Maharashtra, one company is situated in Gujarat. That's the question he is asking.
Sir, in this case, basically, the transferor company concerned ROC get ROC report, basically regional director of transferee company seeks report from the transferred company. So there is no specifically it is required to be submitted.
In your first
No, no,
case, in
what is that
relation,
answer? No, no, what is that? There are two states are involved here,
yeah,
right? When the two states are involved, one the transferor company is in one state, transferee company is in another state, then obviously you cannot go under one RD unless until the RD is falling in the same jurisdiction. That is a different thing. Otherwise, it has that both the RDs have to approve that. Just like two high courts are approving earlier, same is the case here also. So in such cases, what happens is earlier what we used to do to bring it under one jurisdiction, we used to change the register office of the transferor company. So that
correct. That is what normally people do. Yeah.
the things will be faster. The same is the case if you want to do it under fast track merger scheme, you have to do like this only. Otherwise, both the RDs have to clear that.
In your first case, in relation to the fast track merger of the IDFC, I learned that one of the companies was a listed one. So how it is possible to go ahead with a fast track merger? Drisha is referring the case of the IDFC. He says, I learned that one of the companies was listed one and how it is possible to go ahead with the fast track merger.
Meanwhile, go to the remaining queries, Bala.
Okay. The moment the proposed change are allowed under the section 233, 90% cases will be shifted to RD from NCLT, reducing the burden of the NCLT. I cannot say what will be the statistic because unless until so much small companies, other people are there, because this is actually specified classes of the companies. All the classes of the company cannot come under this 90%, whatever you think. I have my own apprehension on that. Anand sir, you can add your view.
Right, sir.
Does this mean that though two wholly owned subsidiary do not qualify as a small company, still can apply to the RD merger if the parent is the same? What is this question actually is continuation of earlier question or what? I'm not able to get this. Does this mean that though two wholly owned subsidiary do not qualify as small company, still can apply for RD merger if the parent is the same? No, it will not come under the specified companies because only specified companies can go for the fast track merger. How can it be?
Yes.
Whether the merger include demerger also under the fast track? Somebody is asking the question whether demerger also come out under the fast track.
I
Yes,
don't
sir.
think so. The demerger, how can it come under fast track? Because
Demerger,
fast track mergers is talking about, merger and demerger are two separate things. So 233, the way it is legislated, it is, I think, only talks about mergers, not about demerger.
correct. Absolutely, you are right. Because 233 very specifically talks only merger. There is no
Not
mention
the
about the
demerger.
demerger. So obviously the demerger will not come under this topic at all actually. Can we make a company wholly owned subsidiary on the current date and initiate the merger process of the wholly owned company with the holding after 1 month from therein, like it is allowed to initiate fast track merger through the making the transferor of wholly owned subsidiary company 1 or 2 months before adopting the scheme only? Yes, Anand sir, what do you think? He said,
Yes,
I will make the current state the wholly owned company and I will apply for the fast track merger.
Can do it. Actually, the day you are moving your application, if the company is qualified, why not? Simple it is. The day you are moving your merger, fast track merger application, if both the transferor and transferee companies are qualified, you can go ahead. Yeah.
Okay. This is Rakshish Shetty from the Sankida Mobiles. We, in the process of the fast track merger, we have doubt in a scenario where the company is obtaining no objection certificate from the creditors holding 90% or more of the value in lieu of converting the formal creditors meeting. Is it mandatory for the creditors company to issue a board resolution authorizing the person signing the NOC?
Obviously, it has to be. Otherwise, without his power, how can he do it? Either he should have a power of attorney or a board resolution authorizing him to give that kind of an NOC.
Can a holding company, transfer company, be merged with the wholly owned subsidiary company, transfer company, and the first? I think we answered this question actually. Approve the unsecured creditors also required to fast track merger, given that they are not affected by the merger. This also we discussed actually. Whether the valuation report is actually mandatory for both the transfer company and transferee company.
Yes, sir. It is required.
Newspaper publication is required for the fast track merger.
No, sir.
At what stage is the questionnaire receipt that we talked about it?
Yes, sir.
Like he talked about this one, but what stage the objection and other things is received that we already discussed. Share exchange ratio, how it will be decided?
It is on the valuation report only, sir. It is based on valuation report. This is on ratio of a proportion of that share is being distributed.
Under section 230 subsection 6 of the Act, approval of the majority shareholders is required with a value of not less than 3/4 of the shareholder. Is it 3/4 in number or value or both? Or it is majority number more than 50% or 3/4 in value, present and voting? I understand we are not discussing NCLT method, but I had a doubt on this.
So because he is adding here that valuation report is not required, but we have confronted a situation where RD has specifically asked that how you have got the basis of this allocation of share. In that case, we got the valuation report done from the valuer. That was the only option.
When RD sent the fast track merger case to the NCLT, then what are the reports or compliances required are for the companies to do so? So when you go to the NCLT, then you have to follow the NCLT rules and you have to go by the same thing, whatever you are going, the normal NCLT merger. 99% not falling under the definition. That's right. Somebody is telling you, thanks, Sudhakar. 99.99% wholly owned subsidiary. Cross-border report. In case of the two states, etc. Okay. Our consultant saying that we have to make a BSE as a designated stock exchange and they will look after your scheme. Please advise.
Yeah, appoint us as your consultant, then we will advise you.
He is right in saying that because the regional stock exchange
Obviously, yeah.
got their files transferred to BSE. So therefore, they are asking them to go to BSE. Recently, we have confronted with the Delhi Stock Exchange, similar case. They advise us to go to BSE to seek the report from them.
Just wanted to understand the intention of only the intention of only involving foreign holding into Indian wholly owned subsidiary only under the fast track route. Will there be a possible amendment in the future to also include the foreign wholly owned subsidiary Indian holding? Yeah, she has given the proposal here, and on the proposal, when it comes through, we'll have to wait and watch. Valuation report under section 230 is not required, sir. In case of the merger of the holding subsidiary and so, he said actually valuation is not required, but at the same time, when the question comes to the share ratio, etc., that causes the problem. That is where the valuation comes to safeguard your interest. This all depends upon the circumstances to circumstances. Can we challenge the RD's order rejecting merger before the NCLT? RDs are challenging. I don't think RDs are
See,
challenging.
to my knowledge, it cannot be. Then you have to go through that NCLT process.
As
In
you
the
Yeah,
said.
fast
RD,
track merger scheme, RD,
Yes, sir.
Bala, am I clear? That say under fast track merger scheme, RD is the supreme. Okay. And if he rejects that, then that means under fast track merger, you cannot do it. NCLT has no jurisdiction on fast track mergers.
correct.
And if you want to
RD,
go to appeal to that, huh?
see,
You are right,
RD
sir.
can,
It shall be
Yeah,
RD
yeah,
an
Bala,
can,
go ahead.
RD can either reject or they can actually accept. That is the
yes.
only thing. He can approve or he
Correct.
can reject. Once the approval taken place, your fast track merger goes up. It is reject, you have to go to the NCLT. There is no other way. There is nothing called the appeal and other thing and all. There is nothing.
You
Yeah,
have to go
appeal
through
is
the NCLT scheme because you know that you cannot appeal against RD in the NCLT.
Correct.
appellate authority in case of NCLT is already structured, but in case of RD there is no appeal.
Correct.
Yeah.
Because RD is the supreme authority in this case. That's the end of it. But only
Yeah.
two options. Either approve or reject. If it is rejected, you go to the other jurisdiction. That's it. If the prior RBI approval is required in case of first, I think we discussed this actually because of the cross-border merger. There is no provision under the section 233, whatever it is, but approval will be actually called for it. I think that is all the questions I have on the chat box. I have done with all those things. If there are anybody who would like to ask the questions, etc., they can raise their hands. We can answer. Let me see anybody has risen the hand actually. I don't.
Only you raised your hand, Bala. No one else has raised. You're on mute, Bala.
Yeah, Disha is asking a question. Disha Pandya. Yes, go ahead.
Sir, I thought by mistake, sir. It's me only.
Okay. I thought you wanted to ask a question. Yeah, okay, no problem. I think that's all. Since there is no questions actually coming from the people, I think we can definitely call it a day today. I would like to express my sincere thanks to Mr. Anand, as usual to Sudhakar. And Disha has actually put up everything very nicely elucidated with the relevant provisions and also along with the proposed changes which are going to be there actually. Yes, as people have expressed, it is ease of doing business. It is like the cost effective. It is actually giving a procedural saving, etc. for the smaller companies. We hope this will actually come in more and more regulations, will actually facilitate in the ease of the doing the business, and it will take off well, I think. But our company secretary need to know the provision, as Sudhakar repeatedly said again, knowing the provision, knowing the things, knowing the OA, etc. and everything, that one has to take care either the employment or in the practice. That's what I would say. Thanks a lot to everybody. With this, the webinar comes to an end. Yet we'll meet yet another seminar in the next week. Thank you all. Wish you a good day.